Is the U.S. Supreme Court on the cusp of striking down so-called assault weapons bans as well as so-called high-capacity magazine bans? If we are, this might be how it looks because the U.S. Supreme Court is involving itself in the Illinois Protect Illinois Communities Act, which is basically an assault weapons ban. Where is this going? What does this mean? What do you need to know? I have attorney Lucas Vebber from the Wisconsin Institute for Law and Liberty, a seasoned constitutional law attorney from the trenches from coast to coast, who's going to be helping me unpack what's going on here. Guys, let's get into it. So the plaintiff in this case owns a gun store, and he's in Naperville, which is a suburb of Chicago. And Naperville enacted their own, basically, assault weapons ban of sorts that banned the sale of AR-15s along with, I think, about 26 other types of weapons. And then along comes the state of Illinois, who said, hold my beer, wait till you see what I've got. And they passed the Protect Illinois Communities Act, which is effectively an assault weapons ban, just all sorts of stuff. Covered in another video. We'll link that description box below. And that brings us to the fact that they moved for a preliminary injunction to stay those laws from going into effect. And he lost. And this is the Northern District Court of Illinois. So we're talking federal court. He then winds up appealing it to the Seventh Circuit Court of Appeals, also based out of Illinois. They deny, and then the U.S. Supreme Court got involved. What happened?
Yeah, so what the Seventh Circuit did was when he got to the Seventh Circuit, he filed another motion seeking, or the plaintiffs in the lower case filed another motion seeking a stay pending appeal. So the Seventh Circuit denied that request, so they're still considering the original underlying appeal. What he then did was petition the U.S. Supreme Court to say, well, they're considering that, you should put it on hold, U.S. Supreme Court. So the way that it works procedurally is that each justice has circuits that are assigned to them, appellate circuits. The Seventh Circuit goes to Justice Amy Coney Barrett. So that petition gets filed with her. She has ordered the other side to respond to that petition, and then she can either decide to rule on it herself, or she could refer it to the entire court for a decision.
Now, I don't know these statistics, and I'm sure someone with Google can find them out really quick, but suffice to say, the U.S. Supreme Court has a lot of people reaching out in lawsuits asking them to intervene every year.
Most definitely.
They don't get involved in 98% plus probably, maybe even more.
I think those are fair numbers, yeah.
Guesstimates. So the fact that Amy Coney Barrett has asked for the Illinois and the city of Naperville to brief their side, this is big deal, safe to say.
Yeah, I think it certainly shows an interest from the court, and to get the court's interest is a huge deal. Absolutely.
So if they were to get involved in this, and if they were to accept the case, is it safe to say this is what that process looks like?
Yeah, so what they could do, Justice Barrett has really three options. She could deny the request, she could grant the request, or she could refer the request to the full court for their decision on it. Basically, the legal question before the court is whether they're going to put it on hold pending appeal below. So if the court grants it, the laws wouldn't be in effect. The appellate court considers the underlying preliminary injunction. It's very, I guess, confusing, it sounds like for most people, but I think at the end of the day, it will have significant impacts on the merits of the case, because one of the factors the court has to consider is whether they're likely to succeed in the underlying appeal, right? So they have to kind of look at that and say, and what the court says here will have tremendous impact, very likely, on the outcome of the case.
So I'm going to take a stab at this, because I'm not nearly as versed at suing the government as you are, but I'm going to take a stab at trying to wrap this up for folks if they're looking for the English definition of what's going on here. The English definition of what's going on is that the lawsuit has not actually been decided in the Northern District Court of Illinois. Rather, the question of whether or not we're going to press pause on the laws going into effect, that's been decided by the trial court. Now we're going up to the U.S. Supreme Court, who may get involved on that issue. Mm-hmm. But the significance of this is that when the U.S. Supreme Court, if they do decide to take this case up, even if it's on a preliminary injunction basis, in other words, all they're looking at is the injunction. Mm-hmm. The important thing is that if they do decide to get involved, they're going to be saying, okay, guys, here's how we call a ball or strike. AR-15s, magazines, accessories, all that kind of stuff. This is protected by the Second Amendment or it's not. This is what the analysis looks like, because, the quick overview, and we'll link in the description box below if you want to see the full breakdown in this particular Illinois law is, they're banning the possession, transfer, sale of numerous different types of so-called assault weapons. Of course, America's most popular firearm. They're banning possession of rifle magazines, I think greater than 10 rounds, pistol magazines greater than 15 rounds. And among their arguments in court are the fact that, well, AR-15s are not protected by the Second Amendment because they didn't exist at the time of the creation of the Second Amendment back in 1791, which is a frivolous argument, and I'm not saying that. That's what a federal court has called that argument. And they're also saying that magazines and other accessories are not part of a firearm, therefore they're not protected by the Second Amendment, and therefore they can do whatever they want. And of course, this is the gist of the legal framework. I threw a lot at you. Am I going down the right road with that?
Yeah, you are. I think, the Supreme Court could, if it gets referred to the whole court, we could see more, I guess, writing from the court on this. If Justice Barrett just grants it or denies it, she may or may not submit some reasoning with that when it gets denied. But if she could just grant the preliminary injunction, it would then go back down to the Seventh Circuit to consider the underlying appeal, but it would be stayed while they consider whether to enter that injunction, which once that's resolved, the case then goes back to the district court in the Northern District of Illinois, which would resolve the merits of the lawsuit.
So down, down, down.
It would go back down, yeah. And this is all, this is typically how lawsuits against the federal government on these types of fundamental rights cases go. Because these issues are so important, you need to have an injunction at the front end. You can't ask a litigant to be subjected to losing their constitutional rights while they litigate whether or not their constitutional rights are in fact being taken away. So it's very important. It's a common procedure that we see time and time again. But it's not common for the U.S. Supreme Court to get involved in this type of stuff and to show this level of interest. So,
and one of the other kind of interesting in the weeds issues here is the fact that in these sorts of cases, as I understand it, that there is an irreparable harm that is imputed to any First Amendment sort of regulations out there. In other words, when the government tries to regulate First Amendment, one of the things that the movement, i.e. the plaintiff, the person suing, they have to show in order to get a preliminary injunction granted, one of their prongs is irreparable harm. And if the government's trying to do something that seeks to regulate speech, religion, something like that, you don't have to demonstrate irreparable harm. It's there. And Second Amendment, of course, has long been treated as a second-class right, to say the least, and sometimes a very distant second-class right. Something that I like about what came out of the Southern District Court of Illinois, again, that link to that video and the full breakdown, because we're not going to do it here, isn't in the description box below. But the judge actually tackled that issue and said, no, this is there is, number one, there's absolutely, just like First Amendment, Second Amendment's not a second-class right, so we're going to just impute irreparable harm. But then he goes into, even if you don't, here's how we get it there. Just broadly speaking, do you think that one of the big issues coming out of this could be the so-called second-class right? Do you think that this is something courts are going to be taking up as we look down kind of the stretch of the next 10 years?
Yeah, I think that's a huge issue right now. I think, the Second Amendment right is obviously one of the fundamental rights protected by the Bill of Rights. But as you said, it's sometimes treated as a second-class right or something less than the First Amendment and some of the other rights that are protected there. I think this is something that courts are grappling with now and litigants are bringing up. It's something that, the Supreme Court will likely give us some clarity on, I think, at some point in the not-too-distant future. And that will go a long way, and it'll have a tremendous impact on lower courts and how these cases are litigated going forward.
If the U.S. Supreme Court decides not to take up a lawsuit like this, i.e. we're dealing with basically a so-called assault weapons ban, an AWB, it seems pretty clear to me where we're going because, frankly, we're already there. It's not a matter of where we're going. It's where we are, which is that this whole class of firearms are completely lawful to own in this, somewhere between 60 to 70% of states or so. And it's a felony over here. And you're going to just have a complete, we're going to have split circuit court decisions. You're going to have split decisions just all over the map. And that seems to me like exactly where the U.S. Supreme Court would get involved.
Yeah, typically cases that pique the court's interest, and obviously the Supreme Court can kind of decide which cases it's going to take, but typically the court wants to get more involved when you have those type of splits that they can resolve and bring some uniformity to the law and bring some clarity to how those fundamental rights are interpreted by lower courts.
So we have a briefing deadline for Illinois and Naperville due May 8th. Okay, so that's Monday. So they have to get their briefs back. any idea, and I realize that now we're going to get into speculation land, so let's just get that out there. Any idea how long it might take to hear the next step from the U.S. Supreme Court?
Pure speculation, but I think it'll probably be pretty quick, especially because, this is for relief pending appeal. I think it'll be a pretty quick decision, whether it's grant denial or, again, the third one, it could be referred to the entire court, and the entire court could issue a decision. That typically happens when the circuit justice feels like a particular issue is very important. It's almost like a respect for the issue type thing that they would refer it to the entire court. So that could happen here as well.
It feels like it could happen here because obviously this goes to the absolute core of the issue and might also go a long way towards hopefully avoiding split decisions and just putting the brakes on a lot of these state legislatures we've seen out there, whether in Colorado, New Mexico, Minnesota, Rhode Island, New York, California, Illinois, and keep going on and on and on. All these places passing their own flavor of assault weapons bans.
Yeah, exactly. And if the court was to say no, if they were to deny this request, the case would still go back to the Seventh Circuit, which is still considering whether the appeal on the original denial of the preliminary injunction. So it's a little confusing because you still have that appeal is still live. What they asked, what is being appealed at the U.S. Supreme Court is a request for them to stay at pending appeal while they consider the underlying appeal. So some different layers of procedure here. I know it's a little confusing and kind of hard to follow, but the court could do any number of things. The Supreme Court could, and it certainly won't be the end of it at the end of the day anyways.
All right, so before I get to my last very important question, I want to take a moment. Thank you all for watching this far. If you could, please consider clicking like on this video. Lets us know what's important, what you like. Also, comment down below your own questions. If we can somehow lure Attorney Vebber back out here from his important work at the Wisconsin Institute for Law and Liberty to do a follow-up video to address enough of your questions, we'd love to be able to make that happen. So let's see those questions go up and tell us what you think is going to be happening with this. I realize this is a short timeline, short turnaround, but this is obviously very important stuff, so let us know. Also, please consider clicking subscribe on this channel to make sure you don't miss any of our future content. And of course, show some support for Attorney Lucas Vebber and the Institute, the Wisconsin Institute, World Institute, I say, but the Wisconsin Institute for Law and Liberty. You can check out a link below if you're considering a donation or anything like that. They are a 501c3 nonprofit, so every little bit helps. You can see the link to their website in the description box below. And even if you don't have any money or can't show your support at this time, please consider leaving them a 5-star review on their Google page. Just Google up Wisconsin Institute for Law and Liberty, click write a review, absolutely free. Otherwise, we can't let the only people who leave them reviews be the people who they beat in government, right? Because how much fun is that? All right. So thank you very much. Now back to the question. So my big question for you is, okay, we talked about what happens if they take it up, if Amy Coney Barrett, if the Supremes do something. What happens if they don't? If they don't, does that mean that, oh crap, like is that a oh crap moment? Like we should all be looking at this and saying these assault weapon bans, they're probably going to stick, or just don't read too much into it?
Not necessarily. I wouldn't read that much into it. If they do deny it, the case goes back to the Seventh Circuit, where they will then consider the full appeal of the denial of the preliminary injunction. This case certainly could make its way back up to the U.S. Supreme Court, almost certainly will at some point. So I think I wouldn't read too much into that. But again, you're always reading tea leaves when it comes to the court, and only they know what they're thinking. So we'll have to wait and see.
We'll have to wait and see, and maybe we can lure you back on to help break us down the next.
Always happy to. Always happy.
Fantastic. Well, again, thanks for sticking around this long, and as always, we'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.